Hello, friends. Welcome again to our webcast. I'm Carolyn Lee, principal and founder of Carolyn Lee Pllc, a U.S. immigration law firm dedicated to helping clients build their futures with investment immigration. Well, today we are here to talk about EB-5 under the Reform and Integrity Act of 2022. RIA, or as I affectionately have taken to calling it, RIA. It's here, I can't believe it. So we are going to touch on some of the highlights, just some, and with a view to sort of touching on questions that I think will emerge more as we in the private sector work with RIA, develop our cases, our project structure under RIA, and as the agencies also interpret and implement RIA for their parts. So these are themes that will emerge in the coming weeks and months and years that we'll be talking about right here. The advocacy themes that I think will also emerge in our discussion will also be topics for our discussion going forward. And I can really split up the advocacy themes into two buckets. One is need for speed, need for speed. It's 100 pages of legislation. We have a lot of questions, everybody does. And we are going to need the agencies to give us answers to these questions in a reasonably timely way, and for these answers to be reasonable. And to that end, I'm optimistic that we'll be developing policy and answers to these questions collaboratively as much as possible, with input from the incredible experience and knowledge on this side of EB-5. I'm hopeful that that will happen. The second bucket is the need to take down the visa numbers. We have a backlog in EB-5. We have double the number of EB-5 visas we normally have due to the continuing COVID consular closures and the spillover from unused family-based numbers coming over onto the employment-based side. So it's on us all, and it's on the agencies to help us optimize visa usage. It's more important this year than ever, so we can take down as many of those visas that are available as possible. And RIA allows us to do that with one of its changes, concurrent filings, which I will touch on in covering our highlights. And finally, a raison d'etre for having this webcast today is to let folks know about the upcoming EB-5 industry and bar events. So next week, starting on Monday, is the IIUSA in-person forum in Orlando, Florida. And I'll be there. I'll be speaking at the closeout panel on on Wednesday, the 13th, with some incredible professionals, industry folks who know EB-5, who know RIA, and who are working with it right now. And I'm really excited myself to learn from them and hear what they have to say. So I look forward to seeing you all there. Come say hello. And right after the IIUSA event, we'll be starting the American Immigration Lawyers Association, AILA's EB-5 specific conference that I'm honored to chair. And this will be a workshop delivery of CLEs. We're gonna dive deep into the language of RIA, and our focus will be on helping practitioners really unpack and understand how this will work on the ground as they work with clients. So stay tuned for more details on that. I'll be sending that out across our channels, newsletter, and social media. And finally, CLP events. We are going to be, in addition to our normal immigration investment conversations, we'll be running EB-5 under RIA year one and developing these questions and themes as they emerge and talking to industry folks and experts that I always love talking to and learn from and hopefully you will as well. I know you will. So let's start. Highlight number 1, Regional Center Program Reauthorization for 5 years. This is meaningful. We're really going to get to see how this new regime change in the EB-5 program is going to play out. Regional Center Program reauthorized until September 30, 2027, at least. Some substantive changes. Well, of course, one of the headliners is the investment amount threshold change. It is now $800,000 for TEA investments and infrastructure, a brand new category, and $1.05 million at the non-TEA level. And I think the question here is going to be how the market reacts to these investment level threshold increases. And that'll be interesting to see what markets emerge, what markets will be sensitive to it, other opportunities that crop up. Stay tuned. The second is TEA, Targeted Employment Area, High Unemployment Area designations. States are out, feds are in. It's only DHS that will have the authority to designate TEAs. I think our question is for everybody, how is this going to happen? Again, the need for speed. EB-5 is based on transactions, and we need to know whether an area qualifies, or really more specifically, whether the agency will deem an area to meet the high unemployment area definitions. And the statutory definition has a new formulation. So we're going to need to have the agency respond to this. What we don't want, what would be absolutely disastrous, is for us to see 4 or 5 years down the road when investor cases are filed and investment is in, money spent, to discover that the agency disagrees with the TEA determination. We want to avoid that. Set-asides, of course, 3022. 32% of our annual allocation of roughly $10,000 will be set aside for investments in rural high unemployment areas and in infrastructure projects. 20% of the 32 in rural, 10% of the 32 in high unemployment area, 2% in the new infrastructure category. So the question here is, how are the agencies going to implement these set-asides? It's going to require coordination between the State Department and DHS or USCIS, and it's going to need to figure it out. The agencies are buying themselves a bit of time. On the visa bulletin, we read that the State Department is absorbing the new law, and also on the USCIS side as well. And this is going to be one of the major questions that we will need answers to. New regional center oversight measures. Of course, this was at the heart of Reform and Integrity Act of 2022 and has been for the last 7 years. And there are extensive oversight provisions in RIA. So the questions are going to be, how are these going to be implemented? Of course, on the private sector side, but also on the agency side. These are oversight measures that USCIS DHS specifically requested. I remember in a letter from Jay Johnson, then Secretary of DHS, writing a letter to Senator Grassley, saying we need statutory oversight authority to implement the oversight measures that you would like us to see. Well, they've got them now, pages and pages of it in RIA. So we are going to be looking for how the agency is going to implement those oversight provisions and that authority it now has. And we are going to be looking for notice. We're going to be looking for guidance. And we're going to be looking for how the agency uses its resources. These are intensive. There are going to be site visits that are required. There's going to be regional center audits. There are going to be record keeping monitoring requirements. So how is the agency going to implement these oversight provisions and authority it asked for? I'm curious to see what the material differences are going to be as they emerge at the end of the day. Are we going to see this sea change and a different feeling about the program? Are we going to have more confidence? Is this going to feel like a tighter program? I mean, this was the intent. This was the desire of Congress. So, or will we see changes more at the incremental level? Will it be more of a slow going evolution of which this was just a part or a step? That'll be very interesting to see. Mandatory pre-approvals. So this exemplars or pre-approval applications filed on the project side by the regional center will now be required. Before RIA, it was not mandatory. Some projects had exemplars, that's another term for it that we were using, or pre-approval applications and approvals in place, and investor petitions as well, and some did not. Under RIA, it's a requirement. They have to be filed first before investor petitions can be filed. And as I read it, they have to be approved before the investor petitions can be approved. So we see this with the mandatory requirement of pre-approvals, we see this closer alignment and linkage between the project filing and the investor petition filings. So again, need for speed. We can't have the investor cases pending for years and years and years if the pre-approvals are not adjudicated within a reasonable period of time. And I think that we do have some benchmarks for what are reasonable set in RIA in the fee study section of the new law. So we're again going to need to focus on reasonable timeframes for RIA implementation. Mandatory fund administration. So this is one of the oversight provisions and it's brand new. We'll have to see how it rolls out. Each new commercial enterprise is going to have fund administration procedures in place that monitor how the funds move as the investors place their capital at risk. New investor grandfathering provisions, huge victory. Wow, what an effort. And the investor advocacy organizations deserve a lot of credit for this, especially AIIA and other advocacy groups, including, of course, IIUSA, very much behind this effort to get grandfathering into the new law. What would it do? Well, it's got two aspects to it. One is insulation from retroactivity, protection from retroactivity. This means that if there's a future change in the law, it's not going to affect investors who filed under a prior law. Their cases will be decided under the law in place when they filed. Very reasonable. The second aspect of it is continued adjudication. Well, we've experienced what it's like when investor cases stop, when there's no adjudication, when there is a lapse of the regional center program. Hopefully there will be no future lapses, and certainly not as long as 8 to 9 months. But if there is a lapse in the future, investor cases will not suffer stoppage in their adjudication. They'll continue. So this is great. This gives investors coming in now a lot more confidence, I think, and it should, that their cases will continue to go on, even if the regional center program itself should experience a lapse. Finally, actually, I've got two more. Concurrent filings. This is a game changer. Concurrent filings exist in other employment-based green card categories. If there's immediate visa availability, the petitioner can file concurrently at the same time for green card by filing an adjustment of status application. We didn't have that in EB-5 before. Now we do. So that means unless the investor is from a country that's backlogged, if they are otherwise adjustable under the law of adjustment, which is its own separate thing, then these investors can file adjustment of status applications and apply for work and travel authorization and be in the queue to take down a visa number. This is big. So this is a very good, it's a provision that we all should be aware of and be taking full advantage of. Now, finally, good faith investor protections. This is a section that I'm so proud and pleased to have worked on closely over years with both public and private partners to protect good faith innocent investors who are caught in the maelstrom of regional center terminations and now potential new commercial enterprise debarments. This is a sanction that can now happen under RIA. Those investors are not out of luck as they had been. Their immigration cases can continue. Their priority dates may be preserved. Their children may be preserved from aging out. They may be protected from deadlines that are coming up. Huge. And I'm not going to feel embarrassed in saying, if you are in this situation or if your investors are, please do contact me. I would be so pleased and happy to help apply RIA's good faith investor protections to these cases that might benefit from them. That's a good note to end on. So we will. I will look forward to seeing folks in Orlando in person. I will look forward to talking to you at the AILA EB-5 conference events and seeing you on CLP's EB-5 under RIA Year 1 webcasts to come. Take care.